My legal sources tonight are criminal defense attorney and former Manhattan Assistant District Attorney Jeremy Saland, CNN legal analyst and criminal defense attorney Joey Jackson, and the retired federal judge Shira Schindlin. And Judge, it's great to have you. And I want to start with you because we obviously don't know. We're not actually in that jury room, unfortunately, as much as I would like to be able to listen to what they're deliberating. But the sense that we got from these notes today, I heard some legal experts saying that it was a bad note for the defense because what they were asking for was to be reread the testimony of David Pecker, the first witness, this tabloid king. And he was the first witness. But in those closing arguments last night, Joshua Steinglass, the prosecutor, told the jury, you've got to use your common sense here. Consider the utterly damning testimony of David Pecker. And now they seem to want to consider that a little bit more.
Well, Pecker was the first witness. That was weeks ago, and they may want their recollection refreshed. My guess is that some people in that jury were already convinced, and others said, convince me. And they said, we'll convince you. Let's hear what Pecker said, because he said something quite damning for Trump. So I think in the dynamics of their conversations with each other, one group challenged the other and said, let's do it. Let's hear Pecker.
Yeah, well, and just to remind everyone, because the testimony was so long ago, David Pecker, was friends with Donald Trump for decades, Joey. And in one of his testimonies that we know is going to be reread to the court tomorrow, because we got to hear, as they were deliberating what it was the jury was asking about. One of those quotes is where David Pecker said, there was a discussion about that, how I was going to be the eyes and ears of the campaign. There was a discussion that I would be notifying Michael Cohen of any women that were in the process of or going to be selling their stories. And I would notify Cohen that they would be available and that they would either have to buy them or take them off the market and kill them in some manner. I mean, what do you make of the fact that the jury wants to hear that again?
I make quite a bit of it. I really do. Why? Because remember the theme and the theory of prosecutors. This is about a conspiracy and a cover-up. Now, conspiracy is not charged, but it would imply two or more people are engaged in illegality. What is the illegality here? The falsification of the business records for a specific intent, right? To violate some other law. So if you're going to conspire, you go to the beginning. What did that look like? Who was in the room at the time? What were you talking about? What were the relevant things you were attempting to do? What was the end game? What were the participants like? What were you planning on? And so, to me, that really brings them back there as it relates to Pecker. And it also means to me, Caitlin, that they're crediting, or at least one or more are crediting what Pecker had to say. If you want to hear from someone again, it means that you were impressed enough to want to know what they had to say. Additionally, I would say, one of the instructions, as we know, is that you can disregard in totality a person's testimony or take such portion that you believe to be believable and disregard the rest. Who else did they look to hear from? Cohen. Mm-hmm. And so that means to me that they're not ready to disregard him at all, but ready to hear what he has to say relative to a critical issue.
I'll first off by saying I agree with the judge, and you should always agree with the judge. So I'm in absolute agreement. And there may very well be a few people who are on that fence or disagree. And once you have where the conspiracy was born from and where it was birthed, which is in that first meeting in August of 2015 with Pecker, with Trump and Cohen, and then you take that a next step because there's that phone call involving McDougal. I don't buy stories, but talk to my guy, Michael Cohen. It really corroborates everything. And part of the argument from the prosecution is, you don't have to like or trust or really care much about Michael Cohen as a whole. But in this moment in time, he was honest. He may be a discredited, not a very credible person and someone you may not even like. But in this moment, we know he was truthful. Why? Because of Pecker.
Well, the other reason that Pecker is so important is he says the intent of all this was about the election. And that's critical because it's an election fraud crime, right? Underlying. So it's important that the reason they want to suppress those stories is to affect the election, not to protect the family.
No. That's a great point, Judge, because no one, and we don't know yet, this is the first time they've sent a note back. We don't know if they'll send more notes back or just these two. Mm-hmm. And we'll get to what the second one was in a moment. But this note was not about falsifying business records or asking a question about the instructions necessarily on the checks or the invoices. It was about the conspiracy to influence the 2016 election. That's why people think it's bad for the defense.
Well, we'll see.
I think it's absolutely bad for the defense. I don't know how you read it to the contrary. Now, if you're reading it to the contrary, that maybe there's a juror who just can't be convinced, you're way too early for that. You're really in the birthing of this case. They're bringing that out for the same reason we just all said. This is what happened. This corroborates the theory of the prosecution.
I'm willing to be a little more skeptical than you. It may be more than one juror who can't be convinced. It may be that, in my experience, jurors often took a straw poll as soon as they got in the jury room, and that gave them the early reading. And if it's a split, like 7-5 or whatever, they know they have work to do. And so they figure out, how does the majority convince the minority? And they think that through. And here's the way. You got to hear what Pecker said. You got to compare it to what Cohen said. If they agree, he's corroborated. After all, he's only an accomplice. He needs corroboration. The documents do the trick, but the witnesses do too.
So you see it as a sign of disagreement among the
Potentially.
Early.
We are all reading tea leaves, and I don't take it as a major disagreement. It's just the beginning. Maybe some people said, it's got to be beyond a reasonable doubt, and I'm not there yet. That's what I might say if I was a juror.
Without question, Judge, but I think it goes back to what initially was the plan. And remember what the other theory of the prosecution was. Stormy Daniels is the motivation. Why? Because on the heels of Access Hollywood and the rocking of the campaign, we don't need another story like this. And it gets us back to what the initial agreement is. How are we going to catch it, kill it, and what are we going to do about it? Who's going to be responsible?
We used to call it a bimbo eruption. We don't need another bimbo eruption right now. Remember that?
That language has clearly changed as we have shifted on.
Hope Hicks did a good job of establishing that. She made it clear that when that Access Hollywood tape hit, the fear and concern for female voters, how that would impact the election. So all this collectively, and it starts, I think, with David Pecker.
And importantly, they're also asking for the instructions to be reread. It's not clear if it's the full instructions, but the jury made clear, which I know you have strong feelings, that they don't get a copy of these jury
I want to
instructions.
talk about that. In federal court, where I sat for so many years, we always sent the written charge into the jury room, not one copy, but 12. Every single juror had it. It was their roadmap to how to deliberate. They went through it. And it was the only way to go. And I'm just so surprised that New York State doesn't allow that.
Judge, before we go, I do have to ask you about this other claim that Trump is making, because it's picking up steam. You can always tell when something's out to kind of just bust out there. And he's saying falsely that the judges not requiring there to be a unanimous decision on each of the counts. He posted this earlier.
No. I'm sorry to correct you. There has to be unanimous decision on every count. What doesn't have to be unanimous. Trump is saying. I'm sorry. Trump is saying.
This is why I wanted to ask about this, because Trump is claiming that there doesn't have to be a unanimous decision on each of the counts.
It's in the charge. I read the entire charge.
There's a wrinkle to it.
No, of course I know that. The underlying, the one that you have the other crime that you intend to commit or conceal, that, according to the judge, doesn't have to be unanimous. But I'll say that there may be an appellate issue there.
Yeah, well, Trump has made clear that would be their alternative if he is convicted here. Judge Sinlin, Joey Jackson, Jeremy Saland, great to have you all here.